Have you ever seen an eviction case collapse before the board even hears the evidence, simply because the termination notice was drafted poorly? I'm Mr. T, Ontario Paralegal Explains, explaining a real lesson from a recent Landlord and Tenant Board decision. I changed the parties' names for privacy. Cities are mentioned, not full addresses. The law and case authorities remain accurate. The dispute arose in Etobicoke, Ontario. A landlord applied to terminate a residential tenancy under the Residential Tenancies Act 2006. Often called the RTA. This statute governs most landlord-tenant relationships in Ontario. The landlord alleged willful undue damage to the rental unit. The relevant statutory authority is Section 64 of the RTA. That section allows a landlord to terminate a tenancy if a tenant, an occupant, or a permitted guest willfully or negligently causes undue damage. Willful means intentional. It means the act was done deliberately, not accidentally. Undue damage means damage beyond normal wear and tear. Wear and tear is the natural deterioration expected when someone lives in a property. The landlord served a Form N7, Notice to End Tenancy, for causing serious problems in the rental unit. An N7 notice is used where the alleged conduct is serious. Examples include significant property damage or safety risks. Importantly, unlike some other notices, an N7 has no remedy period. That means the tenant does not get a period to fix the problem before eviction proceedings begin. After serving the notice, the landlord filed an L2 application. An L2 application is the procedural document that asks the board to terminate a tenancy and issue an eviction order. This is different from an L1 application, which is used only for non-payment of rent following an N4 notice. Many new practitioners confuse these forms. That mistake alone can sink a case. The hearing occurred by video conference in January 2026. The landlord was represented by an agent acting under a power of attorney, often abbreviated as POA. A power of attorney is a legal document authorizing one person to act on behalf of another. The tenant also had an agent. Now here's where the case turned. The landlord's N7 notice contained only one allegation. It said that on August 1st, the landlord's son visited the unit and saw damage consistent with intentional destruction or extreme misuse. That was essentially the entire description. No details, no explanation of what was damaged, no location in the unit, no description of how the damage occurred. 1 week before the hearing, the landlord sent an evidence package with photographs and additional explanations. But the board member ruled the notice fatally defective. Fatally defective is litigation language, meaning the document contains a flaw so serious that it cannot legally support the claim. The decision relied on the Divisional Court precedent Ball v. Metro Capital Property. The Divisional Court is an appellate court of the Ontario Superior Court of Justice. Decisions from that court are binding on tribunals such as the Landlord and Tenant Board. In Ball v. Metro Capital, the court held that eviction notices must contain sufficient particulars. Particulars is legal terminology meaning specific factual details, details that tell the opposing party exactly what conduct is being alleged. The court explained that a termination notice must identify the behavior complained of with reasonable precision. This includes information such as dates, times, and the nature of the conduct. Why? Because of a fundamental legal principle called natural justice. Natural justice is the procedural fairness rule that every party has the right to know the case against them and the right to respond to it. If a notice is vague, the tenant cannot meaningfully prepare a defense. When a notice fails this requirement, the notice becomes a nullity. A nullity means a legal document that has no legal effect. Lawyers often say it is void ab initio. Void ab initio is Latin. It means void from the beginning. That is exactly what happened here. The board member reviewed the N7 notice and concluded that it did not explain what damage occurred. There was a date, but no description. The tenant therefore could not identify the specific allegation to answer. The landlord argued that the evidence package sent before the hearing fixed the problem. The board rejected that argument. The law is clear. A notice must be valid on its face at the moment it is served. Evidence provided later cannot retroactively cure a defective notice. Retroactively cure means fixing something after the fact. The law does not allow that here. Because the notice was defective, the board did not proceed to evaluate the substantive evidence of damage. In civil proceedings, the decision-maker normally decides facts using the balance of probabilities standard. The balance of probabilities means the claim must be more likely than not to be true. In numerical terms, practitioners often explain it as greater than 50% likelihood, but the board never reached that stage. The application was dismissed before the merits were considered. This is called a threshold issue. A threshold issue is a preliminary legal hurdle that must be satisfied before the tribunal considers the underlying facts. Here, the defective notice stopped the case at the threshold. Now let's talk about paralegal competence. Competence means having the knowledge, skills, and judgment necessary to represent a client effectively. Ontario paralegals have a professional obligation to maintain competence under the Law Society of Ontario. Drafting eviction notices is one of the most common places where competence failures occur. When drafting an N7 notice, the paralegal must provide clear particulars. Ask 5 questions. Who caused the damage? What exactly was damaged? Where in the rental unit did it occur? When did it happen, or when was it discovered? How did the damage occur? For example, instead of writing intentional destruction, a competent notice might say, on August 1st, 2025, the landlord's representative observed 3 large holes punched through the drywall in the living room north wall, approximately 2 feet above the floor. That sentence contains particulars. Another example, kitchen cabinet door torn off hinges and sink faucet broken. Again, specific details. The goal is simple. When the tenant reads the notice, they must clearly understand the allegation. Another competence lesson concerns form selection. Ontario eviction notices include several different forms. An N4 is used for non-payment of rent. An N5 is used for interference with reasonable enjoyment, damage, or overcrowding. The first N5 includes a 7-day remedy period. An N7 is used for serious damage or safety issues and does not provide a remedy period. Choosing the wrong form can be fatal to the case. Next lesson, understand the relationship between notices and applications. A notice such as an N7 is the first step. It informs the tenant that the landlord intends to terminate the tenancy. If the tenant does not move out, the landlord files an L2 application with the board seeking eviction. The application must include the notice and proof of service. Service itself is another competence issue. Under Section 191 of the Residential Tenancies Act and the LTB Rules of Procedure, documents must be served using approved methods. Examples include personal service, mail, courier, or placing the notice in the tenant's mailbox. Proof of service must be documented. Without proof, the board may find that the notice was never properly served. Finally, a strategic lesson for advocates. For tenant representatives, reviewing the notice carefully is often the first defense strategy. If the notice lacks particulars, counsel may raise a preliminary motion or argument that the notice is invalid. If the board agrees, the application may be dismissed without examining the landlord's evidence. For landlord representatives, the lesson is equally clear. Before filing the L2 application, read the notice critically. Pretend you are opposing counsel. Ask yourself, does this notice tell a complete factual story? If the answer is no, do not file the application. Instead, serve a new compliant notice and start the process correctly. Yes, that means delay. But filing a defective case wastes months anyway. The core lesson is simple. At the Landlord and Tenant Board, the eviction case often rises or falls on the notice. Draft it carefully, because if the notice fails, the case never truly begins.